Common Divorce Misconceptions, brought to you by Barry Law Offices. One of the most common post-divorce misconceptions we see today is the confusion about court-ordered debt. People will walk into our office saying, "My spouse was ordered by the court to pay a debt. Why am I still considered responsible for that debt?" Well, it's simple. Although we understand you were excited when the court ordered your spouse to pay the debt, you need to understand that if your name was on the mortgage, you will still be considered responsible by the bank. This is true regardless of the kind of loan it is. This is because the divorce court does not have the ability to modify contracts and obligations with your creditors. Let's use an example. Molly and Gary recently got divorced. For purposes of this example, Molly was awarded the homestead, which is subject to a first mortgage to Wells Fargo and a home equity loan to Bremer Bank. The court orders that Molly take on the responsibility for both the mortgage and the home equity loan. After the divorce, Gary attempts to attain a mortgage to purchase a new home. However, Gary does not qualify for the mortgage because of his continued obligation under the mortgage to Wells Fargo and the home equity loan to Bremer Bank. Upon realizing this glitch, Gary requests and Molly agrees to attempt to refinance the mortgage to Wells Fargo and the home equity loan to Bremer Bank, so both are in her name only, which would release Gary from his obligations. Despite her best efforts, Molly is only able to refinance the mortgage to Wells Fargo. Although this is enough to allow Gary to get a mortgage to purchase a house, he remains responsible, along with Molly, for the home equity loan to Bremer Bank. 2 years later, due to financial struggles, Molly is unable to continue to make the monthly payments on the home equity loan to Bremer Bank. Molly declares bankruptcy and discharges her obligation under the home equity loan. Bremer Bank brings a lawsuit against Gary to collect the remaining amount due on the home equity loan. Gary objects, stating that during his divorce, the court ordered that Molly pay this home equity loan back. The result? Well, Gary loses. Bremer gets a judgment against Gary for the remaining balance on the home equity loan. In addition, Gary's credit is substantially impacted as a result of the missed payments, and he remains individually responsible for the judgment Bremer Bank brought against him. Again, the court has no authority to modify the agreement Gary made with Bremer when he was still married. Depending on the language contained in the divorce order terminating Gary and Molly's marriage, Gary may or may not have the ability to bring a lawsuit against Molly as a result of her failure to pay Bremer Bank the home equity loan. But the damage has already been done. Gary's credit has been negatively affected, and based upon Molly's bankruptcy, it is probable that Molly does not have the resources to repay Gary for the amount that he's out as a result of Molly's default.